We have a nominee for the Supreme Court to replace Ruth Bader Ginsburg. President Trump has nominated Amy Coney Barrett, who has been a circuit judge on the 7th Circuit where I practice since late 2017. Given that Judge Barrett will potentially be replacing Justice Ginsburg, the anchor of the left wing of the court, this is likely going to be the most brutal confirmation fight, at least during my lifetime. Let's put all the histrionics to the side. Forget the politics, forget the grandstanding. Let's take a few minutes and do a deep dive into Judge Barrett's background, her academic writings, and especially her almost 3 years in the 7th Circuit. And let's see what that tells us about how a Justice Barrett would actually shift the court on important issues. Let's start with a bit of Judge Barrett's background. Judge Barrett is a graduate of Notre Dame Law School. She graduated first in her class and was the editor of Notre Dame Law Review. After law school, Judge Barrett served a pair of clerkships, as many top law school students do. Her first clerkship was with the Honorable Lawrence Silberman, a well-regarded conservative jurist who authored important decisions on the Patriot Act, the Second Amendment, and the America Cares Act. After clerking for Judge Silberman, Judge Barrett was able to obtain a prized clerkship with Justice Antonin Scalia, the favorite justice of a generation of conservatives. After completing her clerkship, Judge Barrett went to practice with Miller, Cassidy, LaRocca, and Lewin, a blue-chip firm in D.C. that is about as politically connected as you can get. In fact, Miller Cassidy has represented Richard Nixon, Ted Kennedy, and more recently, Ivanka Trump and Jared Kushner. To cut to the chase, it's the exact type of firm that people that want to be involved in Washington politics seek out. Judge Barrett quickly left private practice, however, and pursued a career in academics where she distinguished herself. While working at Miller Cassidy, she took a position as a visiting professor at George Washington University Law School, and then returned to Notre Dame in 2002, where she taught federal courts, constitutional law, and statutory interpretation. By all indications, Judge Barrett was a fantastic law school teacher at Notre Dame. She received the Distinguished Professor of the Year award 3 times and has had numerous papers published in distinguished law journals, such as the Law Reviews of Columbia, Cornell, Virginia, and Texas. That brings us to Barrett's nomination to the 7th Circuit. On May 8, 2017, President Donald Trump nominated Barrett to fill a vacancy on the 7th Circuit Court of Appeals. As I litigate frequently in the Northern District of Illinois and other district courts that are supervised by the 7th Circuit, I remember her nomination very well, and I remember looking into Judge Barrett's background at that time. Given that the majority of the cases that I litigate in federal court are intellectual property matters and business torts with the occasional personal injury case thrown in, I remember seeing absolutely nothing that concerned me in the slightest. However, in this video, we're going to be looking at constitutional issues that affect the general public, rather than the very specific procedural and substantive issues that my practice is concerned with. So let's keep going. As is typical in appellate nomination proceedings, Senate staffers pored over more or less everything that Barrett had written, said, or done up to that point. She had never served as a state court judge or a district court judge, so there were no opinions on sensitive issues to review. However, as I mentioned a moment ago, Barrett was a prolific academic writer, and Senator Feinstein latched onto an article that Barrett had written with Notre Dame professor John Garvey. The title of the article is Catholic Judges in Capital Cases, and the subject of the article was the interplay between Catholic judges' duties as a judge and the duties placed on them by the Catholic Church. As this article is somewhat important to understanding the controversy around Judge Barrett's nomination, I provided a link to this article in the description of this video so that you can review it yourself. Now, I remember this article caught my attention when Barrett's nomination to the 7th Circuit was announced. The concern is obvious. Was Barrett a judge that would be guided by religious convictions rather than by the facts of a case? To cut to the point, I skimmed the article at the time, and in a mere 47 pages that covers a variety of Catholic and legal topics, Barrett and Garvey came to the conclusion that judges should follow the law, and if they felt they could not follow the law, they should recuse themselves. The final lines read, "Judges cannot, nor should they try to, align our legal system with the Church's moral teaching whenever the two diverge." This conclusion is entirely non-controversial, and is exactly what an ethical judge should and would do. So other than feeling that Judge Barrett's writing was perhaps a bit on the dull side, back in 2017, this article really made no impression on me at all. On the contrary, the article apparently made an outsized impression on Senator Feinstein. Senator Feinstein confronted Barrett about the article and asked Barrett to elaborate on the statements and discuss how you view the issue of faith versus fulfilling the responsibility as a judge today. Barrett responded that my personal church affiliation or my religious belief would not bear on the discharge of my duties as a judge, and it is never appropriate for a judge to impose that judge's personal convictions, whether they arise from faith or anywhere else on the law. Apparently, Feinstein was not reassured by Barrett's statements, as the senator responded, "The dogma lives loudly within you, and that is a concern." This was picked up by the national media and served to make Barrett an absolute favorite of religious conservatives who rallied to Barrett's defense. The same exchange served to demonize Barrett with the left. Numerous LGBT civil rights organizations co-signed a letter opposing Barrett's nomination. The opposition to Barrett was bolstered by a letter that she signed in 2015 where she endorsed the definition of marriage as being between one man and one woman. She testified that the letter and its message were legally irrelevant. In addition, every law clerk that she served with and all 49 members of Notre Dame's faculty endorsed her. Nonetheless, her confirmation to the Southern Circuit had been cast as a battle between the left and the right, and she ended up being confirmed by a vote of 55 to 43, with only 3 Democrats voting in her favor. Now, Judge Barrett has served on the Seventh Circuit since November of 2017, and during those nearly 3 years, she has taken part in and even authored a number of significant opinions. Let's cover a few. To start, Judge Barrett has not ruled on any case where abortion was a central issue, so none of her opinions are going to shed light on how she is likely to rule on that particular divisive issue. However, proponents of the Second Amendment have every reason to believe that a Justice Barrett would be an ally. In Kanter v. Barr, Ricky Kanter appealed from a judgment that he was prohibited from owning firearms after pleading guilty to 1 count of mail fraud. Mail fraud is a felony, and both the federal government and the state of Wisconsin have laws prohibiting felons from owning firearms. In this case, Barrett was on a panel with Judges Flom and Ripple, and while the latter 2 judges issued the majority opinion upholding the prohibition on felons owning firearms, Judge Barrett authored a verbose and spirited dissent. In particular, Judge Barrett took issue with prohibiting non-violent felons from owning firearms and would have found both the Wisconsin and federal statutes unconstitutional. I have included a link to the decision in the description below. Judge Barrett's dissent starts on page 27 and continues until page 64. In those 37 pages, she goes into great detail the history of the Second Amendment and the application of gun laws in this country that serve to disarm classes of citizens. After reading this dissent, it is quite clear that a Justice Barrett would be a strong voice for the Second Amendment on the Supreme Court. Similarly, it is clear that a Justice Barrett would be a solid proponent for the protections of the Fourth Amendment. There are at least 2 opinions that Judge Barrett authored that are relevant to this issue. First, Judge Barrett authored the opinion in Rainsberger v. Benner. This is a disturbing case involving a man that was accused of murdering his mother and a police detective that submitted a probable cause affidavit that was riddled with lies and completely excluded any exculpatory evidence. This evidence resulted in Rainsberger being imprisoned for some time until the case was eventually dropped. He then sued the detective and eventually ended up before the Seventh Circuit on appeal. Judge Barrett had no problem at all in determining that qualified immunity did not shield the lying detective's conduct. She cited to Supreme Court precedent that stood for the rule that it violates the Fourth Amendment to deliberately falsify allegations to demonstrate probable cause. Second, Judge Barrett also authored the opinion in United States v. Watson, which is a bit more interesting case, as she distinguished precedent that would seemingly have allowed the government's conduct under the case Navarrete v. California. What happened in this case is that police in Gary, Indiana received a tip that some boys were playing with guns in a parking lot. The police arrived, searched Watson's vehicles, and discovered 2 firearms. Watson was a convicted felon, was charged with unlawful possession of a firearm. The trial court refused to suppress the guns, and Watson entered a conditional guilty plea, which he appealed on the grounds the guns should have been suppressed as the police did not have reasonable suspicion to search his car. The government argued that under Navarrete, an anonymous tip provided reasonable suspicion because the caller reported his own contemporaneous observations. However, Barrett distinguished Navarrete by finding that Indiana allowed open carry of firearms with a license, and therefore a tip that someone was openly displaying a firearm would not give rise to a reasonable suspicion of a crime. In particular, Barrett found that the police were right to respond to the anonymous call by coming to the parking lot to determine what was happening, but determining what was happening and immediately seizing people on arrival are 2 different things, and the latter was premature. Watson's case presents a close call, but this one falls on the wrong side of the Fourth Amendment. One decision of Judge Barrett that will almost certainly come up during the confirmation hearings is Dovey, Purdue University. This case involved a suit by a male student that had been found guilty of sexual assault by Purdue University, and as a result had been suspended by Purdue for a year and also had conditions placed on his readmission. He had lost his spot in ROTC along with his ROTC scholarship and effectively lost any opportunity to pursue a career in the Navy after graduation. The male student argued that Purdue had violated his rights under the 14th Amendment by using seriously flawed procedures to determine his guilt or innocence, and it also violated Title IX by imposing a punishment on him that was influenced by sexual bias. A magistrate dismissed the male student's complaint and he appealed. This decision reinstated his suit. As I indicated before, this case is going to be brought up before Judge Barrett's nomination proceedings because sexual assault hearings on colleges are coming under heavy scrutiny right now. One side claims that the present procedures, which accord male students who are usually the accused almost no ability to put on a defense, are adequate and necessary to protect the female victims. The other side claims the present procedures are the equivalent of a kangaroo court, with every inference being drawn in the favor of the accuser rather than the accused. This case demonstrates that Judge Barrett is squarely in the latter camp. With regards to some of the specifics in this matter, Judge Barrett vigorously took issue with the procedure that Purdue used to rule against the male student. The investigator did not interview the alleged victim. Purdue did not allow the male student to present evidence in his favor. They included an erroneous, which means false, confession from him, and generally just appeared to believe the accuser rather than the accused without any particular reason for doing so. In other words, the facts of this case are not the best for the university, and while I'm sure that it will come up during the nomination proceeding, it probably should not, as it really was quite an easy case to decide on. Turning to immigration, Judge Barrett has authored a very controversial dissent in the case Cook County v. Wolf. This decision addressed the Trump administration's public charge rule, which in essence attempted to impose a condition whereby if an immigrant relied on any kind of public aid, housing assistance, SNAP, what have you, that would disqualify the immigrant from obtaining any kind of lawful residence, a green card, citizenship, what have you. The majority of the Seventh Circuit panel found the rule unconstitutional and granted a preliminary injunction blocking implementation of the rule. Judge Barrett authored a 40-page dissent where she argued vigorously that while all existing precedents supported the majority's decision, in this case the executive, meaning the president, and the people that work for him, should be granted broad discretion in interpreting the immigration rules. This is the first decision of hers that I reviewed that I really thought was result-based rather than based on logic and reasoning. Nonetheless, at least the Fourth Circuit would generally agree with Judge Barrett, so it may be that I'm just missing the point of some of her arguments. This decision is 82 pages long, but if you're interested in the confirmation proceedings, it is worth a read. In another decision that will not make immigrant right proponents happy, Judge Barrett authored the majority decision in Yafai v. Pompeo. Yafai is a U.S. citizen whose wife, a Yemeni citizen, applied for a visa to come live in the U.S. with her husband. The visa was denied twice, and Yafai filed suit alleging that he was being denied his constitutional right to live in the United States with his wife. Judge Barrett held that even if there was a constitutional violation, the court lacked authority to disturb the consular officer's decision to deny Yafai's wife's visa application because that decision was facially legitimate and bona fide. There was a vigorous dissent in this case authored by Judge Ripple, and I find the dissent's reasoning a lot more convincing than I find Judge Barrett's in this decision at least. What can we gather from all this? How will Judge Barrett rule on divisive issues before the Supreme Court? First, it is pretty apparent that Judge Barrett is a proponent for civil liberties and individual freedoms. However, I am not sure that her appointment will shift the court substantially. Justice Ginsburg was certainly a pro-government rather than pro-individual justice. So in that sense, the court will shift. However, the civil liberty branch of the court is already pretty strong. There's 5 justices there already. And Judge Barrett is not as pro-individual liberty as, for example, Justice Gorsuch. Accordingly, with one exception, I do not believe her appointment will shift the posture of the court with regards to individual liberties. That one exception is the Second Amendment. Judge Barrett appears to be a very strong proponent of the Second Amendment, and together with Gorsuch, Alito, and Thomas, will likely drive the court toward expanded firearm freedoms. Second, it appears that Judge Barrett has some bias against immigration, and I would expect that she would break the immigration stalemate on the court right now. I expect that she would drive the court to greater restrictions on immigration. Third, let's talk about abortion. I hate the subject. I made one video on this subject before about a topic that I consider to be pretty non-controversial, at least within the realm of abortion, and I got some truly epic and nasty comments. Nonetheless, I suspect a lot of people that watch this video are going to watch just to get where I think the court will go on abortion with Justice Barrett, so let's get into it. While Judge Barrett has never ruled directly on an abortion decision, there are some indications of her views. First, Judge Barrett has commented that she views it as very unlikely that the Supreme Court would strike down the core holding of Roe v. Wade, meaning the core principle that a woman has a right to an abortion. However, she has also indicated the fight now is over funding, meaning she's apparently open to challenges about federal or state funding for abortions. Based on this, I think that a Justice Barrett would entertain new restrictions on abortion and would lean towards allowing the restrictions. This will likely create a majority on the Supreme Court that will entertain new restrictions on abortion and perhaps allow restrictions that have been rejected to be heard and enacted again. In particular, along with Kavanaugh, Gorsuch, Alito, and Thomas, I now believe that there will be a solid 5-justice majority that will be in favor of new restrictions on abortion. Nonetheless, I cannot say for sure that Barrett will shift the court's position on abortion. Justice Roberts was assumed to be staunchly pro-life in his views and has proven to be otherwise. So we will have to wait and see. Given that Barrett is almost certain to be confirmed, it is just a matter of time before an abortion decision comes before her. That is all that I have for you today. I hope you found this video to be entertaining and informative. If so, please feel free to subscribe, and as always, likes and comments are always appreciated. I'll respond to all serious comments. Finally, have a fantastic day.